Hello everyone. My name is Gitahi. I am a researcher based in Uganda with interest in refugee governance and localization and meaningful refugee participation. I am a member of Just Tech and Migration, and today's event, titled Biometrics, Tech and Human Rights, is co-hosted by Just Tech and Migration and the Institute of Humanities and Social Sciences by the Queen Mary University of London. So a little bit information about Just Tech and Migration. This is a community that is made up of scholars, civil societies, and other actors that are interested in collectively addressing the growing harm caused by digital technologies deployed in asylum seekers' safe spaces. So before I go ahead and introduce the panelists of the day, we have a few housekeeping. So for starters, please feel free to use the chat for any questions, Q&A for any questions that you have. And then secondly, we will not tolerate any rude comments. In case that happens, there is a person in charge of exiting any of the members of the audience with such. And then finally, we request that at the end of this session, we will share forms that we request you fill in with feedback on the session, how we can get better. These forms will be received by our partner, which is Amnesty International. And in particular, this is Charlotte. Her email address is going to be shared in the chat box. So let's start with our panelists today who are very who have a wealth of experience in biometrics, tech, and human rights. To start us off is Dr. Keren. So Dr. Keren is a senior lecturer at the School of Politics and International Relations, and she is a fellow at the International Humanities for Social Studies. Dr. Keren has 15 years of research in East Africa with a high focus in Kenya. She's also a books reviewer editor for the journal Africa, which is one of the premier journals dedicated to the study of African society. So again, Dr. Keren is currently working on 2 new book projects, and she has previously worked for civil societies like Amnesty International, Privacy International, and Campaign Against Arms Trade. Next, we're going to go to Dr. Daragh. So Dr. Daragh is a senior lecturer in law and a fellow at the Institute of Humanities and Social Sciences. He specializes in international human rights law of armed conflicts, with a particular interest in the use of artificial intelligence and other advanced technologies. So before that, he was a research fellow at Edinburgh School of Law. Dr. Daragh has been awarded a fellowship for the UK Research Institute Future Leaders Fellowship to examine the development and functioning of democratic societies. So Dr. Daragh is currently co-authoring a facial recognition, surveillance policing, and human rights as the age of artificial intelligence. And Dr. Daragh has a PhD in law from the Essex University, an LLM in international human rights law from the Irish Center, and an MSc in computer security and forensics from Dublin City University. Finally, we do have Dr. Dimitri. So Dr. Dimitri is a lecturer in law and also a fellow at the Institute of Humanities and Social Sciences, Queen Mary University, London. He's currently a researcher on the impact of the new digital technologies on global security, governance, with a focus on counterterrorism and border security. He is interested in forms of inequality and exclusion enacted by practices of algorithm. Dr. Dimitri was a researcher fellow at Edinburgh School of Law, and he's also working with UKRA UKRI Future Leader Project. So Dr. Dimitri writes on changing practices of international laws for international organization. He is an affiliate fellow at the Institute of International Law and Justice at the New York University. He holds a PhD and LLM in international law from European University Institute and a major of laws from Ghent University. The doctor has also worked with World Bank before and the London School of College. So to start us off, I'm going to pass the stage over to the panelists. I think to start us off, we'll have Dimitri, Dr. Dimitri. If not, please, we can have Dr. Daragh.
Wonderful. Thank you so much, Mary. Thank you so much for that. So indeed, I'll go up first. I'm going to try to share my screen. I think that should work now if all goes well. So thanks so much for that kind introduction, Mary. And it's really nice to see all of you this afternoon. So we have a little bit of a diverse audience today. So I'm going to be sharing some more general insights on border tech that pop up in my research, and then also have some reflections on what the repercussions are for these technologies for how we think about human rights law in this context. So on the opening screen here, you see two recently adopted strategies, one in the European Union and one in the UK, about the use of new technologies and artificial intelligence in particular in the field of border control, migration management, and security. So, and the strategy that was commissioned by the European Commission and that was written by Deloitte, the aim is to come to a new strategic understanding of how AI can be leveraged in the context of border control, migration, and security. And in this document, quite interestingly, the Commission identifies 9 different areas of opportunity for artificial intelligence. And this ranges from vulnerability assessments based on emotion AI in the context of asylum, to data analytics for identifying suspicious travel patterns, and the algorithmic screening and triaging of visa applications and border crossings. The 25 UK border strategy also seeks to harness, and I quote, the power of technology and innovation to create a contactless digital border system. This is aimed to revolutionize crossing the border for both traders and travelers, and to improve the UK's ability to detect threats before they reach the border. So this whole idea of detecting threats before they appear or materialize is quite crucial, as I will touch upon in both strategies. And so to this end, the 2025 UK border strategy aims to, and I quote, develop advanced risking systems to target interventions more effectively using AI-based decision-making. Now, both strategies, I think we can understand in relation to 3 different kind of trends that we see appear in the field of migration, security, and technology. Now, the first is the problematic of prediction. The idea, as the EU strategy states, that it is not just the objective to verify and identify known persons, so to identify known persons and known risks, but to identify unknown persons of interest based on specific data-driven risk profiles. So in this sense, the strategy states AI would enable processes of risk assessment performed on a group of individuals with the aim to find patterns and cluster individuals for further investigation. So this first trend is sort of the typical orientation towards the unknown that we have seen in post 9/11 security governance, where the idea is to govern not the known risk, but the orientation towards the unknown through practices of risk assessment and risk analysis. And so AI is used here, and data analytics are used here to find patterns, propensities of possibly dangerous or deviant behavior in order to identify the as yet unknown risk. The second phenomenon that we see at play in both these strategies, I think, is the problem of the data deluge. The fact that border agencies and security agencies are drowning in data, that there are often simultaneously coexisting databases that have to be made interoperable. The slide should be mentioning interoperability here. So this is the idea that we need new technologies in order to connect all these vast amounts of data that we have in as yet scattered locations and spaces, and that we need analytic tools or algorithmic tools to find patterns across these scattered data sources. So the UK border strategy mentions in this context that it wants to provide for the first time a comprehensive and holistic view of data at the border. It wants to ingest data from a variety of sources and enable real-time sharing of data-driven risk insights across government departments. So this is the role of technology in creating connections in as yet scattered digital ecosystems. And I think the third phenomenon that we really see at play here is the increased intertwinedness or entanglement between public authorities and private actors. We see that, of course, already in the fact that Deloitte has written the EU strategy. We also see it in the fact that the Cerberus program of the UK, on which I will speak a bit more in a minute, has been developed by the British Aerospace Engineering, which is a private corporate actor. And it comes out very explicitly in the UK strategy, which states, and I quote, "The private sector must take the lead on border innovation, with government creating an environment that encourages experimentation and technology adoption." So what we see here is the distribution of labor, where the government has to provide an institutional and legal architecture that enables or encourages experimentation and innovation, where the private sector takes. And so these are kind of the general three underlying phenomena against which we can understand the emergence of these new strategies. Now, digging a little bit deeper into the EU strategy, we find the following quotes that kind of capture the essence of what is going on here. So first of all, DG Home expresses its enthusiasm about using AI in these fields of border control, migration, and security in Europe. And then the next quote, I think, really captures this, the essence of what goes on here quite clearly. So classification categories, and this is about risk classification categories. So the idea of classifying who poses a potential future security threat or risk. Well, they can be defined on known risk thresholds or specific indicators, so certain causal factors that we associate with a higher propensity towards risk, or they can be less predefined based on some learned similarity. So this is where artificial intelligence and the use of machine learning comes in as a technology that allows to find patterns, similarities, propensities, clusters, and data, according to which applications can be grouped and risk can be assigned. So this is the idea of learning similarities, finding patterns in data sources, for which AI is, of course, very useful. As the final quote also indicates, this is the orientation towards finding patterns in data that can inform preemptive security interventions. Now, one concrete application of this strategy, which is mentioned in this strategy as well, is the ETIAS system, which is currently under construction. So ETIAS is the European Travel Information and Authorization System, which will basically be the European Union's way of dealing with the entry of third country nationals into the EU. Now, if we look at Article 33 of the ETIAS regulation, it sets out that the screening rules, which will determine on access or the or refusal of entry, shall be an algorithm enabling profiling based on specific risk indicators. So ETIAS wants to measure against three different forms of risk: security risk, illegal immigration risk, or high epidemic risk. And so these risk factors will be assessed on the basis of an algorithm enabling profiling. Now, this algorithm will be developed, or is to be developed, by Frontex based on specific risks identified by the EU Commission. In a recent delegated act, the Commission clarified that these risks would be determined on the basis of, quote, a particular set of characteristics distilled from data that signal a heightened propensity to patterns of refusal of entry, overstaying, identified security threats, or observed disease outbreaks. So in other words, the way in which these screening rules will be determined is by algorithmically determining what kind of patterns emerge that can link people to those who have already been identified as security risks, illegal immigration risks, or high epidemic risks. So in this sense, this practice of pattern detection will necessarily be a live and iterative process of review and adaptation, where observed attributes and correlations become part of an open-ended taxonomy of risk. The role of Frontex now is to develop risk indicators on this basis, which would allow for the automated processing of applications. And in doing so, it is to be aided by the recently created EU Innovation Hub for Internal Security, which explores how AI can be developed to optimize the performance of risk profiles. Decisions here then will no longer be based on stable legal signifiers such as nationality or citizenship, but on characteristics and correlations that are temporally tied to patterns and propensities in data. So in this calculus of risk assessment, what we see is that the legal subject is being reconfigured and reenacted into a cluster of inferred attributes, a relational association between data points. So this is what we see in the development of the ETIAS system, and we see that something quite similar is going on in the context of the UK border strategy, and specifically the development of its Cerberus system, which is currently underway, and which is supposed to replace the semaphore architecture for decision-making at the border. Now, the ambition of Cerberus is to maximize data-driven automated decision-making at the border, which has resulted in a cooperation with BAE, as I mentioned before. This system, which is somewhat awkwardly named after the multi-headed guardian monster of the underworld, is designed to ingest a variety of data sources and to provide real-time risk assessment at the border. Using machine learning systems, its key purpose is to bring different sources of data together and distill, once again, meaningful patterns within that data. Patterns of behavior that would signal a heightened propensity to risk and allow for, I quote, more targeted security interventions. Now, while these developments are ongoing, so we see really the proliferation and the rise of the security infrastructure, at the same time, we also see how this is countered by regulatory or legislative initiatives. And so these initiatives, what we see here are captured, for example, in the European Union AI Act, which explicitly mentions the use of AI in migration, asylum, and border control management as an area of high-risk AI use. And so how the AI Act works is, for those who are unfamiliar, it kind of differentiates between prohibited uses, high-risk AI, and then low-risk AI. Sorry, I'm just seeing the chat. And migration, asylum, and border control management would be qualified here as high-risk AI uses. And so this is an important kind of regulatory countermove, which explicitly mentions the use of AI for risk assessments, including security risks, irregular migration risks, or health risks, which are precisely those that I have spoken about just now in the relation to the ETIAS system. So these systems are qualified to be high risk in the AI Act, which leads to all kinds of regulatory requirements, including transparency, non-discrimination, risk management structures, etc., human oversight, etc., etc. So we have this kind of turn towards new border tech, of which I have given some examples and tried to go a little bit to the underlying logic. And at the same time, we then have this sort of regulatory legislative countermove that seeks to contain the perverse effects of those. Now, in doing so, and this is where I want to end, perhaps on a slightly more theoretical note, I think what is important here is to think about the concept of affordances. And this concept of legal affordances is a concept that has been developed by Julie Cohen, Mireille Hildebrand, and others. And sort of one quote by Julie Cohen that explains this quite clearly is that discourses about fundamental rights, and I quote, often rely on a set of unstated or unexamined assumptions about a material environment's affordance, about the conditions of possibility that material environments offer for individual, collective, or organizational activity. So if we want to take technological affordances seriously and think about the affordances that systems like ETIAS or Cerberus offer, we have to think about how the design of these systems and our socio-technical environments condition and constrain our possibilities of political or legal action. Now, important here is that what I try to explain is how decision-making and this algorithmic risk assessment and ETIAS and Cerberus no longer relies on fixed causal criteria of enmity or risk or deviance, but rather on correlational associations between data sources that are analytically analyzed to detect previously unknown risks. So we are now bound together in clusters and fluid objects continuously recomposed as new data is ingested. If we think in this context how to make a non-discrimination claim, we see kind of what I mean with the point of affordances. Of course, we know that the digital border, just like any border, has a discriminatory and exclusionary function. It determines the parameters of inclusion and exclusion, and as people like Tendai Achume has argued, has an inherently racializing function. However, as Kotwark and Taopan argued, at the digital border, we no longer appear as single coherent subjects or as populations stratified according to characteristics of bodily difference, but we appear as shifting clusters of data. Now, in relation to our position within these shifting clusters, liberal legal arrangements and human rights standards such as non-discrimination law might no longer be available as potent or possible tools to constrain these forms of violence. And there we see how our liberal legal vocabulary of human rights protection might not be afforded by these new technological infrastructures of bordering. And that is an invitation to Keren and to Daragh, who I know work around that. So I will conclude it at that, and thank you for your attention.
Thank you so much, Dimitri. My presentation, I think, will build upon a lot of those really interesting insights. I'm going to now attempt to share my screen. I want to now draw our attention to the African continent and speak a bit about the border externalization practices of a number of intergovernmental agencies like the IOM, as well as EU funding bodies, and the ways in which anxieties and concerns around irregular migration are shaping biometric systems and biometric borders on the African continent. I'm going to be speaking in very broad brush terms, drawing not only on my own research, but also the work of others. In recent years, biometrics have very much proliferated on the African continent for a whole host of purposes. So we see the spread of biometric voting systems, biometric aid and welfare distribution systems, as well as the increasing use of biometrics for entry and exit systems at borders. And quite a bit of these systems are shaped by concerns on the part of countries in the global north, particularly the EU, around anxieties around irregular migration. And I want to discuss three broad kinds of systems. One are the biometric systems that are installed along border points, particularly across the transit countries where there are routes of migration towards Europe. And I also want to speak about biometric systems that ostensibly on the surface don't seem to be oriented towards border control per se, but which are shaped in a whole variety of ways by concerns around irregular migration. And specifically, I want to talk briefly about foundational biometric ID systems, which are also gaining ground across a number of African countries, as well as the use of biometrics by humanitarian agencies. And I think the most emblematic examples of this are the World Food Programme and the UNHCR. Again, some of these systems are aimed explicitly towards border security, and in other systems, we see really the blurring of the lines between policing, border security, and development. And what I want to really focus on in this relatively short presentation is some of the broad misconceptions around these technologies that I often see proliferating in public debates, as well as to a certain extent within debates in civil society, as well as in scholarship. And I also want to talk briefly about the areas I think where more research is really needed. I also want to note that these systems are profoundly hard to study in a lot of ways. There's very profound methodological challenges to studying these systems, to accessing the back ends of these systems, to speaking to security experts and biometric vendors and the various policymakers that are charged with implementing these systems, to seeing how these systems operate on the ground. These are really methodologically difficult areas to study for a whole host of reasons. Not the least are the kind of securitization barriers that really prevent in-depth research into these topics. But in spite of this, I think growing research on these topics, especially research that draws on, I think, ethnographic fieldwork, which has its limitations, but I think often enables one to move beyond policy documents and really see how these systems work on the ground. I think they are inviting us to ask new kinds of questions of these systems. And I want to highlight what I think are three important areas that I think we need to think more carefully about. The first is to not overstate the efficacy of these technologies. It's certainly the case that these technologies in various ways and these systems are enhancing the surveillance capacity of African states, as well as enabling EU member states to externalize borders and extend their reach into African states. But there's many ways in which these systems break down and fail in very fundamental ways. And this failure doesn't necessarily mean that they don't have real effects, but I think we need to be really careful not to, in a sense, feed into the self-serving narratives of a lot of tech companies and security agencies who seek to project an image of these technologies as quite seamless, as panoptic, and as being more efficacious than they necessarily are. Secondly, I think it's really important to recognize the agency of African states in these funding arrangements and partnerships with, for example, European security agencies and policymakers who are funding and promoting the spread of biometric systems on the African continent. I think there's a tendency to think of Africa as a kind of laboratory, and that can really deny African states agencies. There's agency, and there's various ways in which African states, security agencies are not only reshaping these relations for their own purposes, but repurposing these technologies for their own internal aims, and also in many ways seek out these partnerships as a way of participating in a kind of global biometric ideal that enables them to participate in broader circuits of biometric modernity, so to speak. Finally, I think it's quite important that we also redirect our gaze away from Europe itself, and also look at the ways that these systems are ramifying borders within African countries themselves. So I think there's a tendency to focus quite heavily on the transit zones and transit routes to Europe, and ignore the ways these systems are often enhancing various kinds of border making within African countries. So I want to first talk about a few examples of these systems. So there's been a whole host of biometric entry-exit systems that have been implemented across, again, primarily transit zones across West Africa and the Maghreb, and also Central and East Africa. This is a slide presentation from 2017 of the IOM designed and funded MIDAS system, the Migration Information and Data Analysis System, which captures fingerprints and facial images at border points across African countries, as well as in South and Central America, and automatically checks exit and entry data against various kinds of international watch lists. So, for example, the Interpol alert system. And these systems are not necessarily aimed per se at blocking migration. They're very much aimed to a large extent at managing migration. So they're aimed, for example, at facilitating deportation by helping countries to identify origin countries for individuals they seek to deport. The data collected is also used for broader kinds of migration prediction analytics. So it's important to see these technologies also alongside the much more brute ways in which European countries block and prevent migration. So these are part of a kind of suite of technologies and security arrangements that are being developed with African partners. We're also seeing a proliferation of what we might call foundational biometric ID systems. And the one that I in particular study is the Huduma number system in Kenya, which in many ways operate under the rubric of development. The World Bank is a key promoter of digital ID systems under its ID for D or ID for Development project. But there's various ways in which concerns around migration and a desire to quote unquote promote safe and orderly migration is shaping the development and implementation of these broader foundational digital ID systems in ways that I think actually haven't been properly explored. Finally, we see on the continent various kinds of humanitarian biometric systems. So this is one example, the Biometric Identity Management System that is part of the UNHCR's IT case management tools. And here too, the UNHCR has implemented this system for a whole host of purposes, not necessarily with border security and border control in mind. This is very often used as an anti-fraud device, as a way of deduplicating and reducing multiple registrations, and very much fits into the broader kind of audit culture that shapes a lot of humanitarian work on the continent. But there's growing evidence that of various kinds of data sharing agreements between humanitarian organizations and security agencies that make these systems implicated in a whole variety of ways in border control and migration management. So one example of this is that the UNHCR providing biometric data collected for the purposes of humanitarian protection to the Department of Homeland Security when referring refugees for resettlement. And this biometric data is typically kept indefinitely and stored as part of the DHS's indent, biometric indent system, which is an automated biometric identification system. So these three kind of broader sorts of systems in various ways are implicated in border control and migration management. It's really important, however, to emphasize that these systems, again, don't always work in the ways that they're intended to, or in ways that project a picture of panoptic surveillance. So these systems often fail. There's various ways in which proprietary algorithms and biometric vendors competing for one another inhibits interoperability. There's problems of implementation in various cases, and lack of coordination between security services. The system that I have studied in depth, the Huduma number system, at this point appears to be largely a white elephant project. Many of the people that I've spoken to who've been issued with these new biometric ID cards, smart ID cards in Kenya, have complained that these cards are effectively useless. I spoke to one person who recently attempted to use them to board a plane for an internal flight in Kenya, and essentially wasn't able to use this new Huduma number ID, which the Kenyan government claims is going to replace the Kenyan national ID. So there's various ways in which these systems break down that we have to, I think, be more attentive to and look at the ways in which the failures themselves can be productive and generative in a whole variety of ways. I also think there's a need to better understand the agency of African states in implementing these systems. These systems are motivated, there are a range of actors that are motivating the implementation of these systems. We see networks between the African Union, the European Union, the IOM, various UN bodies, the World Bank, the International Civil Aviation Organizations, all playing a role in various ways in kind of complex networks of funding and knowledge production and knowledge sharing around the implementation of these systems. And in some cases, the role of EU funding bodies and security knowledge is very obvious and paramount. I think we see this, for example, with the implementation of the Senegalese national ID system, which was subsidized and funded through the EU Trust Fund for Africa. And there's already evidence, as reported by State Watch, that this national ID, biometric ID program in Senegal has been used to facilitate deportation and identify origin countries. So there's some very clear links there. In the case, though, of Kenya's Huduma number project, however, despite a lot of whispering and accusations of foreign influence on this project, this seems by and large to be a project spearheaded by the Kenyan government to serve a whole variety of internal political and economic interests. So I think we have to be very wary about assuming that these projects are simply the manifestation of foreign interests and foreign political interests on the continent. And finally, I think it's really important to consider the ways in which these systems are ramifying borders on the continent itself. So a few examples of this. One case study that I've looked at in depth is the case of double registration in Kenya. Double registration is a result of the introduction of humanitarian refugee registration in the country, spearheaded by the UNHCR. As a result, tens of thousands of Kenyans cannot access national IDs because their biometrics are in the refugee system. And really, as a result of the transfer of power and data sharing between the UNHCR and the Kenyan government, there has been efforts to cross-check the refugee database against Kenya's citizen registry. And the Kenyan government, over the years, has seized greater control over refugee registration and refugee management, in large part through support and training and funding from the UNHCR. This has, in effect, enabled them to expunge people from their national registry who are on the refugee database. There are many people in Kenya who are, in effect, citizens who, for a variety of reasons, sometimes out of desperation, have slipped into the refugee system. And now, because of growing interoperability between the Kenya's biometric system and the refugee biometric system, a lot of Kenyans who slipped into the refugee system, for example, to access aid, to access education, to perhaps attempt to relocate abroad, now can't access national IDs. So there's a way in which humanitarian biometrics in Kenya have in effect reinforced a lot of the gatekeeping practices within Kenya itself. And this has very much been at the exclusion of a lot of ethnic and religious minorities, very often Kenyan Somali citizens who have historically faced discrimination. We see very similar patterns in Mauritania, where the introduction of biometric national registration systems, again, very often at the behest of donor countries, has led to the exclusion of historically marginalized Black Mauritanians from accessing identification and accessing really the very symbols, the very kind of documents that enable them to realize their citizenship rights. And this has actually led to a very powerful movement known as Touche pas mon nationalité, don't touch my nationality. So there are also ways in which these systems are not simply kind of helping to control and regulate migration into Europe, but actually in some ways amplifying longer patterns of exclusion and discrimination and gatekeeping practices within African states themselves. I'm going to stop here and hand things over to Daragh, but I want to end by saying that I think it's quite important that we begin to pay more attention to how these systems work in practice, to see the ways they often have unintended side effects, to acknowledge the agency of African policymakers and African states in repurposing and reframing these technologies, and also looking at their limitations and failures, which in and of themselves can have very profound political and economic and social effects.
Brilliant. Thanks, Keren. Thanks, everybody. And big thanks to the Just Tech and Migration community for hosting us. It's really a pleasure to be here. I'm looking forward to chatting to you. I should have my screen shared, I think. So both Keren and Dimitri talked about the kind of really significant human rights harms that can come about because of the use of AI and biometrics at the border. What I want to do is to think through a way maybe we can start to anticipate those harms and engage with them before they happen, ideally. I think before I do, it's important to acknowledge a couple of the really big challenges of AI and biometrics. The first one, I think, is kind of a straightforward one, but you know, AI and the use of biometric technologies, they're both new and they're really complex, you know, so it makes it quite difficult for us to engage with them and to understand them effectively. You know, for me, it's quite a big jump moving from like the prevention or the prohibition of torture or the right to liberty and security to something like understanding how a predictive analytical model works. The second is that these tools are they're often deployed in secretly or with a lack of transparency. So it's really hard to know what they're doing and what their impact is. And that inevitably affects how we react and slows down the process. So because of that, I think it's really important that instead of waiting for these tools to be deployed, waiting for us to understand them fully and then to react, it's really important that we try to proactively engage. And when I'm talking about engagement here, it's across a variety of actors. So it's obviously the states, the EU, or possibly even different corporations that are deploying the specific tools. And what I'm interested in is influencing the decision-making process. So really understanding states' decision-making around whether to deploy a tool or not. And if it's going to be deployed, what are the safeguards or what should that deployment look like? There's a couple of reasons for this. I think the first is that if we deploy, you know, typical human rights methods, you know, waiting for something to happen, taking a court case, issuing a strongly worded press release, it's often a number of years before any real challenge comes about. And so that results in years of potential harm. but also a normalization of the practice. And I think in this field, that's a really important thing to counter. You know, there's often a big reaction or impact to a new technology as it happens. But then a couple of years later, the use of that technology has become normalized and we accept it, and kind of the boundaries of acceptability have shifted in a way that's maybe inappropriate. And the other reason is that I think it's also really important to force states to explain why they do what they do and to provide their reasoning and their evidence base. And this is something I'll come back to. But very often with technology and the adoption of new technologies, the why isn't really discussed. And that's a really, it's a big problem. So what I'll talk about, as you can probably guess from the screen, is a human rights due diligence framework. I explicitly don't call it an impact assessment, which is a lot of the language that's used in policing. And the reason being is that when we think of impact assessments in terms of policing, typically it only focuses on the potential harm. And I think that's only half of the equation. It's really important that we also understand the claimed utility or why a technology is being deployed. So very deliberately use a human rights due diligence framework. And of course, it's important, I think, to use this language because it ties in with the UN Guiding Principles on Business and Human Rights and provides a kind of straightforward way of engaging with the with corporate actors. Apologies if I'm speaking too fast. I just realized I'm probably motoring along in an Irish accent and very not understandable. I'll slow down. So going forward, I think I want to highlight, before I get into the details, a couple of issues with tech and human rights. The first is something that's very prominent in the field, I think, and it's this idea of tech solutionism. And it's the idea that tech is always good and tech will always provide an answer. And I think it's really important that we challenge that. You know, I come from a computer science background. I work a lot with tech. I believe that it can be really, really useful, and that it can transform how we protect and deliver human rights. But it can also cause a lot of harm, and it's not the answer to everything. So it's important that we acknowledge that and really go to the justifications of why a technology is deployed. The second then is that too often we treat tech as a monolith. So rather than breaking it down into specific applications or specific deployments, and something that Dimitri was talking about is probably a good example of that, you know, the use of predictive analytics. If we talk about predictive analytics as a monolith, we miss a lot of the nuance and miss a lot of the potential benefit or harm to human rights. So in a migration context, it's one thing to use, say, predictive analytics to determine migration flows so that we can deploy resources at an appropriate location to help asylum seekers or refugees as they land. It's a very different thing to use a predictive analytics to determine if someone is lying or they're exhibiting suspicious behavior. You know, the human rights benefits and the human rights harms are radically different. And whether we want to deploy or engage with such technologies is different. So it's important that we break it down. The other thing, I think, is that we have a problem with human rights law, or how we have traditionally approached human rights law. And that's that we've always been, by design, really reactive. So typically a harm will occur, we'll take a case, a number of years will pass, and we'll get a decision and we'll move on from there. There are a couple of problems with that. The first is that typically the decision itself is narrow because it's responding to an individual's specific problem or their specific case or circumstances. And so it's very rare that we engage with the full systemic issue, you know, whether the technology should be deployed or not, rather than how it affects this particular individual. The other component, as I've mentioned, is that the harm has already occurred. You know, if a technology is deployed, harm may have been occurring for a number of years. And it's going to be very, very difficult to remedy that after the fact. And of course, we have the normalization issue that I mentioned. And I think a big problem, or a part of the reason for this slowness in responding, or the reactive nature of human rights, is that we were really reluctant to engage in politics. You know, politics was seen as a bad thing. We thought of human rights laws, this kind of neutral arbiter, and politics was something else. And I don't think that's appropriate, because, you know, any decision making is political, and it's really important that as human rights people, we get involved in decision making. The fact that human rights law is typically deployed after the fact means that translating it to a forward-looking kind of pre-deployment or human rights due diligence framework is not straightforward. But the case law does offer some guidance, and that's what I would like to talk about now. So when we think of an interference with human rights, typically the legitimacy of the interference, so whether it counts as just an interference that's legitimate or whether it causes a violation of human rights, is based on a three-part test, whether it's in accordance with the law, whether it pursues a legitimate aim, or whether it's necessary in a democratic society. Most border or policing or government kind of efforts pursue a legitimate aim, so skip over them. But in terms of developing a due diligence framework, in accordance with the law and the necessary in a democratic society, components of the test have something to offer. So the idea behind in accordance with the law is that it's to protect against arbitrary rights interference. So, you don't want to hand unlimited discretion to the state. And so a key here is foreseeability. And so when we think of AI or biometric technologies, it's important that there's a transparent policy establishing when and how the technology is used. And so that gives us guidance on, the components of a due diligence framework. With respect to the necessary in a democratic society, it's important to acknowledge, and this is a thing that comes up a lot with different actors, particularly in government that I meet, this test isn't about, is it necessary to achieve my aim? Because that's a test of utility, is it useful to my objective or not? Rather, it's, is it necessary in a democratic society, which means, is it necessary in light of the overall benefit or harm? And this is typically resolved by analyzing the competing interests. So on one hand, you'll have the competing interests, say, of protecting public order, preventing crime, and then the other side, you'll have protecting the right to privacy, protecting the right to asylum, maybe protecting the right to life, depending on the context. So what this comes down to, for me, really, is an analysis of the claimed utility, what the benefit to human rights is, and what the potential harm is. Within the case law, there's a lot of discussion around how you evidence this, but essentially you need relevant and sufficient justification that should be convincingly established. And what that means is that we really should be talking about an evidence base, and that's something that is really, really missing in the context of AI or biometric deployments, in my opinion. So breaking those two elements down, one after the other, in terms of the claimed utility, the components of a due diligence framework could essentially ask for discrete questions. So the first is, what is the technology intended to achieve? And this is about setting out the objective relevant to the specific deployment. This is something that sounds unbelievably obvious, but is often really missing when it comes to specific tech deployment. So often you'll see, say, something like facial recognition is deployed to protect the public good. But that's a really broad and ambiguous objective that doesn't really set out what you hope a technology will do in a specific context. So just setting out what the objective is really a starting point to really understanding what the impact of the technology can be and how it can be used. The second component then builds on that, and it's, why is it necessary? So if you have an objective or a problem to address, why is it important that that should be addressed? And that comes to the evidence base, is this actually a problem? What do you hope to achieve by addressing it? And so on. But the third component then is, how will you do it? And this relates to the circumstances of use. So really it ties the two together, what's the problem? Why is it important that you address it? And how will you address it? And here, this will get to the specific role of the why biometrics technology, or why an AI decision-making tool. An important component to this, I think, is ensuring that the technology itself is fit for purpose. And so something like a predictive analytics model will be a really good example here, where you might have a model that's trained on a particular set of data and will work in that context. But if you shift it to, say, trying to analyze whether a migration route is suspicious or not, is it capable of doing that? Is the technology itself fit for purpose? And the fourth component then, kind of the utility aspect of the due diligence framework, could be, what are the alternative mechanisms? So a key part of the human rights test is, are there less intrusive means? So, if this is going to be invasive or harmful to human rights to a particular degree, is there a way of making it less harmful? And this can be applied to technology in different ways, such as minimizing data collection, using different technologies. So maybe instead of using facial recognition, in some circumstances, it might be more appropriate to use fingerprinting, but also maybe using no technology. You know, do we actually need to use this tech to address the problem? And that's where you get the overall package. The important component, I think, or the important element of setting out a problem like this is that this will clearly articulate why a technology is being deployed and what it hopes to achieve. And from this can be built the intended circumstances of use. So it's a really effective way, hopefully, of engaging with states in terms of how they employ the technology. And it gives us a means both for them, I suppose, to justify and articulate their objectives, but for us, but also to challenge it on a human rights basis. So it's not just then, I guess, going back to what I said about earlier, not just a political issue or an emotional, we don't think this should be done, but hopefully human rights law can be used more proactively as part of the framework. The flip side of the coin is the potential harm. And I think this is also something that's not usually effectively addressed when we think of new technologies and the deployment of biometric or AI tools in particular. It's important that we look at harm holistically so that we think of all human rights. Very often when we think of tech, it's only the right to privacy and it stops there, but the impacts can be much more significant, you know, and the examples that were given earlier, there's things like the right to claim asylum, but also maybe even the right to life, the prohibition of torture. You know, if someone is returned to a country, you know, these are rights that could directly come into play. Underneath the models themselves, the issue of data protection, which I'm not an expert in, and I'll talk about, is also present, but also discrimination. You know, are the models being used to discriminate directly against people, or are they trained in a particular way that will result in discrimination so that they may, you know, work better or achieve different results, more false positives, say, with different populations? I'll skip over the last bit, but I think the important component to this, to sum it up, I guess, is that we need to have a better way of engaging with states proactively before they deploy technologies. We need to have a way of engaging with them to influence the decision-making process. And I think it's really essential that we start to do this, because otherwise it's just too late. And the technologies become normalized, they are deployed, and significant harm can be done. For me, a human rights due diligence framework is one potential solution. I'm absolutely not suggesting it's the only solution, but it's one way of engaging, because we can use, you know, a generally agreed human rights framework that has more or less universal definitions of harm and how to evaluate them, and we can use that as a basis. I think it has potential benefits to states, because by articulating their reasons and the motivations and providing an evidence base, you know, it helps them articulate their policy and explain why they're doing something, and potentially support them when it comes to future judicial challenge. But also, as human rights people, it gives us a focal point for engagement and a means of really getting stuck into the details and highlighting, you know, the harms that technology could deploy, and indicating whether they should be deployed or not. It's not easy, and I think it requires significant resources, but it is one way, I guess, of potentially addressing the problem. Thanks. I'll hand it back, I guess, to Mary. I'm not sure who I'm handing back to.
Thank you very much, Daragh. That this has been an exclusive presentation from the three members of the panel. And so we still have a few minutes to the end of the session, and we are encouraging all the audience, in case anyone has a question, please feel free to type your question in the Q&A chat box. So I think we will give them a few minutes. Meanwhile, I just have a question to any member of the panel that will feel comfortable. I would just want to understand the role of the role of for example, refugees or migrants are in the biometrics and technology, artificial intelligence. What do you think is their role? And do you think there are any active, I would say, steps that are being taken to ensure that they have, for example, they have information before they get to actively interact with this type of technology? So any member of the panel, feel free to talk about that. Thank you, and you're welcome.
I can start on that one if you want, because it's maybe the only question that I might be able to answer. So I think I was at a UN meeting a few years ago that was kind of a high-level panel with a number of different people, kind of across humanitarian agencies, and they were talking about big data and AI and how to use it. And one of the things that really struck me about it was that it really kind of mirrored the bad parts of a Silicon Valley discussion, in terms of it was very focused on the tech solutionism and like almost the idea that, you know, we're good actors and so therefore we will inevitably do good. And I think that kind of manifests quite well in the use of biometrics around refugee populations, because a lot of the time, I think it's trying to solve a problem or to assist these organizations in what they're doing rather than trying to solve a bigger problem and really understanding the impact. So I think there's a risk that a proper impact assessment isn't done. And so it's undertaking, you know, what are the risks there, you know, because biometric information, you know, it's biometric information. It persists if it gets in the wrong hands or it's handed over to a state, you know, it can be used to target people. The consequences are really significant and much more dangerous than a, you know, a computer file or a handwritten note. And the other issue is that, like, a really big problem, I think, is the issue of consent, you know, and whether you consent to giving your biometric profile or your biometric information over. I think, like, it's impossible to have true consent in that context, you know, just because of the imbalance of power and the impact on the access to resources. And so I think that's an issue that really needs to be figured out properly. I definitely don't have an answer, but it's something there. And I think it goes back to the question of, you know, what's the tech trying to achieve? You know, is it necessary in the first instance, or is there a different way of doing it? Because you can't just dismiss the idea of consent and the longevity of biometric information, I think.
Sure, thank you very much, Dimitri or Keren. Anyone who wants to jump in and say something?
Yeah, I could jump in. Just to add a few things to what Daragh was saying. I think firstly, a human rights framework, while it has limitations, I think it has provided a really important legislative tool in many cases. There's been some really important recent court cases before the Kenya High Court and the Appeals Court challenging biometric systems on the grounds that they're discriminatory and exclusionary. So there were a series of cases that challenged, for example, the Huduma number system in Kenya that were also very much informed by the Supreme Court cases around Aadhaar in India. So there was quite a bit of cross-fertilization. And I think this civil society mobilization that I also referenced, civil society mobilization in Mauritania as well. A lot of it has actually been spearheaded not by refugees, but actually by citizens in Kenya or citizens of states who feel these biometric systems in various ways exclude them or deny them from participating fully in accessing services or accessing the rights entitled to them as citizens. But I think where this potentially has an impact on refugees is that a lot of these cases, I think, often highlight the ways in which the very blurry boundaries between biometric systems for the purposes of refugee management and for the purposes of citizenship management, these systems are becoming inform one another and often are quite interoperable. And there's a lot of shared struggles, I think, between excluded minorities within countries who are facing, who are objecting to biometric systems and refugees who are also, perhaps because of the highly asymmetric power relations, not even in a position to object to biometric systems. So I think there's quite a few opportunities for, and I'm seeing this actually around a lot of the civil society work in Kenya, for there to be kind of shared concerns by both refugees and citizens, as well as a host of people who I think fall into various ambiguous legal categories, whether that's stateless or non-citizen categories, or categories that aren't necessarily neatly captured by international law. But I think there are some real moments where these issues around biometric data management for refugees also interconnect with broader struggles, so to speak.
Okay, thank you very much, Keren. We have questions on our chat box, and the first one reads, I would be interested to hear the speaker's thoughts on whether the challenge to human rights law identified at the end of Dimitri's presentation are how individuals are categorized in dynamic clusters. And hopefully that is a fair summary, can be overcome, or whether it represents an insurmountable limit on the utility of human rights law in digital border contexts.
Yeah, so maybe I can kick that one off, and would love to hear Keren and Daragh's thoughts as well, and to do so also in relation, Mary, to the great question you just asked and the answers that Daragh and Keren gave to that. So I think like the idea of consent, for example, is a really interesting one, and it links also to like the brief example that I gave on the problems of non-discrimination law. So I think underlying human rights law, and I think Barry, your characterization was absolutely spot on. There are a set of presumptions about who the rights holder is, right? So there is this idea of the sort of liberal legal subject underlying it, which is this autonomous being capable of granting consent to a particular operation, right? So, and then the problem is, how has that consent been expressed or exercised? As accepting being in a certain place enough, as accepting a random terms of service in a particular digital environment enough? And the same with sort of the right to privacy, and to what extent can this autonomous liberal subject be perceived and be registered, and what kind of information, etc. Or in relation to anti-discrimination law, on the basis of what kind of criteria can we divide and sort and group people together, and what can and can't we do. And so I think the idea that I'm trying to get across is that that very notion of that distinct, isolated human subject endowed with particular sort of rights and obligations is precisely what is being destabilized here through these technologies. So when these digital bordering practices of clustering and of grouping people according to inferred characteristics, they have no interest in sort of what the quote that I used from Pan and Scott Wark, and in the human being as a single coherent subject, or in sort of crude stratifications according to age, gender, racial divisions. They make subjects and they make humans in a radically different way, right? And in a way in which our traditional human rights vocabulary seems impotent to respond. So on the one hand, Barry, like the question that Barry asks, my response would be, indeed, that seems to be true. And yet, there are, of course, also ways in which we can try to reconquer these human rights affordances. And I think there, the work that Daragh is doing of moving sort of from the reactive to the proactive stage is really important. And sort of one plea that I would like to make, and that where my research is a bit going towards, is how can we think about that in the process of design? So how can we think, like lawyers are really good at thinking about institutional design, right? Like we've been doing that for super long. But how can we sort of start to think about infrastructural design? And how do we build systems that have the material affordances of the kind of human rights protections that we crave for and need? And so like when Daragh moves sort of earlier in the chain towards that due diligence and towards that proactive form, like, could we do that in a way that is not juridical in nature, but that is actually material and infrastructural and design based in nature? So how do we build systems that are still capable of accommodating our human rights vocabulary and standards? So in that sense, I think we shouldn't give up on human rights, but we should sort of rethink what kind of, the ways in which we try to sort of express these normative sensibilities, if that makes sense.
Thank you very much, Dimitri. We have another question. Keren,
can I come in
note,
on that one very quickly? Is that okay?
Yes, please go ahead.
Just because I think it's a mad interesting one, and thanks to Barry for asking it. Do you know, I think that I wrote down what you said there, Dimitri, that the idea of, the inferred characteristics in human being not being treated as a single subject, I think that's precisely the reason human rights law has something to offer. And I think it comes back to maybe what you're saying too on the design of the algorithms and better understanding what a tool can or cannot do. A lot of the machine learning tools that are in place at the moment, they work on the basis of correlation and not causation, and they're based on so like in a simple way, they stereotype. And what that means, I think, is that they can be very good at making population level analysis or group level analysis or decisions, but totally inappropriate for making individually specific decisions. And I think so it's a bit about better understanding that. So yes, we can make an overall decision about what this group may or may not do based on an algorithm, but to say that Dimitri or me will or not do something is really problematic, because that's removing our agency and our dignity, and essentially treating it as a stereotype. I don't think human rights law essentially says that you can't do that yet. I think that it has to be there somewhere, and so it's a way of working it out. But I guess I would see that as a human rights response to the way different algorithms work, and like potential for human rights. But of course, like with anything, human rights law is not the answer to everything, and there will be a lot of cases where human rights law says you can or can't do something, and people will disagree, and that's where like politics and ethics have to come in as well. Something like killer robots is a very good example of that, where the law might say it's fine or it's better, but people may disagree. But we must have a chat, Dimitri, and maybe you too, Barry. That's interesting.
Sure, thank you. And so the question for Keren, as you noted, that the tech and government systems are profoundly hard to study, and not least for the security and power barriers. I find the same when it comes to UNHCR. It was the first time I heard that UNHCR provided biometric data to DHS. Do you have more insights into if so, how UNHCR does the same with the EU or EU countries? As far as I knew, this was not yet the case, at least in 2019. Keren, please.
Yeah, I mean, the short answer to that question is off the top of my head, I don't know about any data sharing relationships with the EU, but I think what you're getting at is really speaking to a broader problem, which is the opaqueness of the kinds of data sharing with third parties that govern a lot of humanitarian biometric systems, and the difficulty of knowing what kind of data sharing arrangements are in place, partly because it's quite difficult, for example, it's impossible to really perform a Freedom of Information Act request in many cases. There are very real barriers to getting answers to these kinds of questions. But I also think this more broadly speaks to the kind of sovereignty challenges that govern humanitarian space. I mean, an entity like the UNHCR, which is operating across many different jurisdictions, and often having to navigate very complicated waters, right? Being in many ways beholden to host countries as well as to donor countries and to their various kinds of security imperatives. These data sharing arrangements often emerge not necessarily out of an explicit desire to form these relationships, but out of the kind of struggles and negotiations around hosting refugees, resettling refugees, and are really emblematic of the really complicated sovereignty challenges that govern humanitarian spaces, where you have multiple state and non-state actors with often very different goals in mind and security agendas influencing one another and often and competing with one another for control over data. So I'm sorry I can't really answer your question directly, but I think it gets to the heart not just of broader methodological problems, but of a need to understand and better understand the networks of power and the struggles of sovereignty that are shaping how biometric data is deployed and shared or not shared, so to speak.
Thank you, Keren. Next question, Dr. Daragh. Impact assessment is being developed in a more searching, more informative, less perfunctory pre-deployment or pre-invention instrument for probing how systems work. What their effect will be on equality, human rights, other values and rights, and not just as a data protection compliance tool. I agree that DP compliance AIs are too weak, but if these advanced and deep forms of AI can be brought on board as a requirement, they could be useful to adjust to your due diligence framework.
Yeah, I totally agree. I think there is a lot to be learned from impact assessments, and they are getting better. I think the point I was trying to make, maybe a little flippantly at the start, is that it's important, yeah, not only that they're not just data protection focused, but also that they really articulate the utility, and at least in a policing context, that's something I haven't seen. You know, I haven't seen the why the technology is being deployed, you know, what it's intended to achieve and what the circumstances of use are. And then what that means then when I've engaged with those when I've engaged with, the associated impact assessments from a human rights perspective, is that it's really difficult to understand, because without the parameters of use being articulated clearly, it's very difficult to understand the potential human rights impacts because they're so varied. And so I think it's more like a call for a clearer articulation of the claimed utility of a technology, and you know what it's intended to achieve and why and how it will do so, that I was more focusing on. But yeah, hope you take your point.
Okay, thank you very much. There's a follow-up question that says, my question was about IA and not AI. Does that make a difference on your answer?
No, I think I think I got it. I hope I did anyway.
Okay, so let's see what else we have on our chat box. This can be of interest in light of question before last and Daragh's comments on being proactive. There is a link to that. Maybe you can click on the link to find out more about that. So I think unless there are more questions, let me see. Okay, so we don't have more questions, and we are 9 minutes to the end of the session. So unless we get another question in the next minute, I would request the panelists to give us kind of closing remarks, and in the context of what do you think the future is, or what do you hypothesize the future is going to be in terms of biometrics and human rights, artificial intelligence, and what must be done to lessen the negative impact that biometrics, artificial intelligence is having to the people of concern, to migrants, asylum seekers, and every other group of people that is concerned with this topic. So anyone can go first.
Yeah, I'm happy to try to do so. I mean, it's of course really difficult considering the sort of richness of what everyone has been speaking about. I think I mean, one dimension that I'm very interested in, for example, and that Keren brought out really nicely, is to think about this there is a sense in which we as academics risk sort of perpetuating this idea of algorithmic smoothness and the capacities of these systems and like how dangerous they are and their predictive nature. And I think we have to do more. And I agree with Keren on that, and thinking about sort of infrastructural failure and friction and things falling apart and white elephants and big budgets and big promises. And then, you know, so I think that's a really sort of important and interesting future research direction, I think. Now, I sort of, one thing that maybe is good for sort of ending comments and that often occupies me is thinking about sort of the relation of the lawyer and the human rights lawyer or the human rights activist in relation to these systems, right? And I think there is a certain sense, and that really links with what Daragh is saying, that very often sort of as lawyers and human rights lawyers, we stand in relation to certain practices from a kind of evaluative vantage point, right? From a sort of ex post compliance, evaluation, litigation, etc. And it seems that this is kind of like an attitude that stands a little bit at odds with what is going on at this moment. So all these strategies and initiatives that I have been speaking about, they are at this moment in the works. They are being experimented, designed, prototyped, financed in different ways. And this is, I think, a space that we have to try to just enter and be part of as people who are sensible to human rights concerns and to legal issues, and to try to sort of change our legal way of thinking about these things from a kind of, how should I say, from like, not to be the judge, but to be the system designer, and to try to sort of change our normative and legal vocabularies in that direction. And so I think that will be a challenge in different domains of global governance, but particularly in the sphere of border and migration management, and considering sort of the scale and speed by which these algorithmic processes are being deployed there. So yeah, that maybe as a kind of set of closing thoughts. Thank you, Mary.
Thank you, Daragh. Keren, anything?
I mean, this is probably a very, sorry, you'll have the last word.
I was going to make a joke, so you can.
No, please go ahead. Okay. Well, this might be a very trite comment, but I don't think biometrics are going away anytime soon. I will say that what has captured my attention of late is the way that controversies around biometric technologies have really captured public attention in recent years, and also the role of kind of civil society mobilization, kind of shifting public discussion, public debate around these technologies. I'm thinking about controversies like the use of the recent controversies around the US military withdrawal in Afghanistan, and the controversies that emerged around what would come of the biometric systems that they left in their wake, or the Human Rights Watch report about the UNHCR's and data sharing controversies around refugee data in Bangladesh. One thing that I think has been interesting is that I think partly animated by these controversies and the kind of PR scandals that they've engendered, there's been a turn to new kinds of digital identity systems. So one recent turn that I've seen is the turn towards ostensibly decentralized models, often through use of technologies like blockchain or technologies or a turn towards digital wallets, which is a very broad term for a whole host of different systems. I think it is, as Daragh pointed out, really important to be specific about the kind of systems we're talking about. But I think that I've seen on the part of, I think particularly government agencies and humanitarian agencies, a kind of a turn to an appeal of other new kinds of identification technologies, partly as a way of responding to this growing criticism from the public and from civil society, and growing public fear around biometric technology. So I think we also have to be attentive to maybe some of the unintended ways in which critiques kind of engender new technological solutions. yeah, that's one of my predictions for the future.
I'll be super quick. I think, first of all, in response to Dimitri directly, I don't think there's any risk of us being associated with smoothness anytime soon. The second, I think it's a really good point that's been made. I think we're really used to using law or human rights law to censure. And I think what we really need to do is rethink and to use human rights to engage and to inform more effectively. And that means like kind of taking it out from legal principles into things that can be applied and practiced so that you can more effectively engage with, you know, like you say, with design processes and so on. I think that's a really interesting way forward, you know, but it's essential because we're obviously not doing a very good job of just, you know, responding to things after the fact. I think Mary had to drop off. Do you want to wrap up, Keren?
No, I just noticed that there are some really good questions in the Q&A, and I'm sorry that we haven't been able to get to all of them, but I hope, as I said, I think this will be part of an ongoing conversation, as I don't think these systems or technologies are going away.
Yeah, and just echoing that, please, everyone who's still around and also those who wrote questions, get in touch and let's keep talking about that together, hopefully.